Welcome to Your Money Guides, brought to you by Interface Financial Planning. Hello. In this short guide, I want to talk about lasting powers of attorney, or LPAs. An LPA is a document which gives a person or people, the attorneys, power to make decisions on behalf of another person, the donor. An LPA is made when a donor has mental capacity, in preparation for when they lose their capacity. There are two different types of LPA: property and financial affairs, and health and welfare. A property and affairs LPA covers decisions about the donor's financial affairs and their property. They can be used by attorneys whilst the donor still has capacity and after they have lost capacity, or only after they have lost capacity. An attorney for a property and financial affairs LPA will be able to buy or sell property. They will be able to operate the donor's bank account and invest any savings, claim welfare benefits or pensions and receive income for the donor. They will also be able to deal with the donor's tax affairs. They will also be able to pay the donor's mortgage, rent and household expenses, pay insurance, maintenance or repairs on the donor's property. It's worth mentioning, any person who has capacity and is 18 years old or over can be an attorney. The health and welfare LPA covers decisions about the donor's personal welfare and health. It can only come into effect once the donor has lost capacity. An attorney for a health and welfare LPA will be able to make decisions on where the donor is living and on their day-to-day care. They'll be able to arrange any medical, dental or optical care for the donor. They will also be able to allow access to any of the donor's personal information. They can consent or refuse any medical treatment and decide on the donor's diet and clothing. It also includes a section where the donor may grant their attorneys the power to make decisions on accepting or refusing life-sustaining treatment. So why make an LPA? The possibility of losing mental capacity can be a distressing thought and is often seen as something that does not need to be considered until the future. However, it needs to be arranged while still having capacity and is best made sooner rather than later. Capacity could potentially be lost at any time, such as through an accident, a stroke or a degenerative condition such as Alzheimer's, and with growing reports of 18 to 45-year-olds suffering from mental health problems, it can happen to people at any age. If capacity is lost and there is no LPA in place, any family or friends will have to apply to the Court of Protection for a deputyship to make decisions on behalf of the donor. This is a lengthier process, costs much more than registering an LPA, and will incur ongoing costs which an LPA does not. It can never be certain that the Court of Protection will approve an application, and they are particularly reluctant to approve a deputyship for a person's health and welfare. By using an LPA, the donor can choose who will make decisions for them and how those decisions may be made. This control is lost if a deputy must be appointed after capacity is lost. Problems can be created where one member of a couple loses capacity. If the majority of the couple's assets are held in joint names and one loses capacity, the other will not be able to access the joint account or deal with jointly owned property without applying to the Court of Protection. Similarly, if assets are mostly in the name of one partner who loses capacity, it could potentially leave the other unable to access any assets or be unable to maintain the home. So what about choosing an attorney? One or more people may be appointed as attorneys. Replacement attorneys may also be appointed to take over in the event the original attorneys are unable to act. No limit applies to the amount of attorneys that can be appointed, but it's not practical for more than 4 to be appointed. Any person who has capacity and is over the age of 18 can be an attorney. For a property and financial affairs LPA, there is also the added condition that the attorney must not be bankrupt or be subject to a debt relief order. Who to appoint is very much a personal decision for the donor, and it should be someone who they trust completely. The common appointment is a spouse or partner, acting either solely with any children as replacements, or acting jointly and severally with the children. This may not always be practical. For example, if there are any family conflicts between potential attorneys, they may not agree on what is in the donor's best interests. It's also possible to appoint a professional as an attorney, and in the case of a property and financial affairs LPA, a trust company may be appointed. Of course, there will be costs associated with this, as a professional attorney may charge fees. If more than one attorney is appointed, then the donor must decide whether the attorneys must act jointly or severally, or jointly for some decisions and jointly and severally for others. For an LPA to become valid, it first needs to be sent to the Office of Public Guardian, or OPG, to become registered. At the moment, there is a registration fee of £82 per document. A certificate provider is also required. This is an independent person who certifies at the time of signing they are aware that the donor understands the purpose and scope of authority given by the LPA, and that no fraud or undue pressure is used to influence the donor into making the LPA, and that there is nothing else which could prevent it from being created. An attorney must always act in the donor's best interests, and cannot take advantage of their position and benefit themselves or another. If any person believes that an attorney is not acting in the donor's best interests, they should contact the OPG, who will investigate, and in serious cases they may even refer to the Court of Protection, who have the power to remove an attorney or even revoke the lasting power of attorney. Thank you for listening. For more information, visit our website at interfacefinancialplanning.co.uk.